Thank you. My name is Joe Pizzullo. I'm an attorney out of Philadelphia from the law firm of Pizzullo Rodin. Tonight we're going to be talking about how the middle income families should prepare for retirement. How I usually teach this program is give and take. As someone who has tried cases, I'm going to give you the negative at the beginning. The negative, you cannot leave this seminar and be an expert in drafting retirement documents or estate documents. But as I teach any young attorney in my office, I fully intend to have each and every one of you be able to sit in a meeting and understand retirement planning. And we have people live here today, and we have an all-time audience on the web. We have over 500 people. If you have any questions, feel free to email them. I'll stop the course and I'll answer them. I'm here to serve you today. For the first hour, I'm going to be going over the general concepts of retirement planning. The second hour, Jeff Pizzullo, who's an attorney in our office for the last 3 years, will be going into the technical aspects of Social Security and retirement funds. Jeff is young, but he has 5 degrees. He has a math degree, a Wharton degree, a law degree, an MBA, and he just got his LOM in taxation. So in our office, we rely on him for very technical support. We have a couple people here live. I want to know your name, your profession, your experience, and why you took this course.
My name is Ganjo. I'm an immigration attorney. I've been an attorney for 16 years. I registered for this program because of this topic. I think as an attorney, I would like to learn more from an expert in this field.
My name is Simeon Stam. I'm a workers' compensation attorney for the last 5 years, and I pretty much took this course because I have a young son, and we're starting out thinking about how to plan for our future retirement.
You're young for retirement.
You never can be too young.
A lot of attorneys want to come in this area, similar to you.
Yes.
A client calls you up, and let's step back a little bit. What's your first name? Gem. I want to retire. What is retirement planning?
Well,
let's sit back and think conceptually, because it can cover many areas. So if a client says to you, I want to retire, I need retirement planning, what do you think he's talking about?
Well, I think the person is either thinking of Social Security benefits, or he is thinking of in-term estate planning if he has considerable asset for such planning. So I would think of this person as a person who is interested in estate plan because he's considered.
For him, because this gentleman just said his son.
Well, I think that would be applicable to a person who is nearing retirement age as well.
So if someone is close to retirement, the first thing, what you're telling me, he's worried about his welfare and his security. His own and his family. What else? Is there anything else in retirement planning? You have a young son. What else do you need?
You want to make sure that they're covered for, whether it be medical, financial.
That's welfare. What else would a client need from you?
In terms of...
He needs documents. That's what we do. That's what attorneys do. So it would be a document review or preparation of documents. Lastly, a lot of them want to know about taxes, death taxes. Do I have the items, do I have my assets properly titled? Should they be in joint names? Should it be in my name? Should it be in my spouse's name? Or should I start buying assets in my children's name? So we talk about this all the time. And a lot of it is elder law. Like you said, we get clients that are approaching retirements and are concerned about elder law. What is elder law? They're certified in New Jersey. There's attorneys in Pennsylvania who constantly say, we do elder law. What are some of the areas of elder law? You said Social Security benefits, and that's what Jeff's going to cover. What else? Pardon me? Estate planning. Anything else? You have a son. What do you need? What happens if you die?
Wills and
Wills, you need documents. And that's estate planning. But for elder people who are retiring, we just spoke to Dave about his grandfather. What are we concerned? A guardian.
their medical expenses.
Medicare, and Jeffrey will go into it, and Medicaid. People want to worry about transferring assets. To transfer assets. Any other. You will become disabled eventually. 85 to 90% of people become disabled. What do I need? What kind of document do I need? Otherwise, you have to have the person declared incompetent.
Power of attorneys,
Power of attorney, and what else?
guardianship papers,
What does every hospital demand if you put your father in the hospital before they're admitted?
end of life documents.
Living will. There's that old cartoon, and it goes back when I was in law school. He still has $500,000 of life in him, and it shows someone in a hospital bed. But in my office, we tell all the clients when they come in for any estate planning, retirement planning, etc., I will demand that they have a power of attorney and a living will. Any other ones? What do other clients? They want to know about titling of assets. Jeffrey and I had a client today. Today, many people have properties in multiple states. They all hate that word probate. I have to avoid probate. And probate in Pennsylvania is fairly reasonable. But I don't want to have to go to 4 states to probate. And the client said to me, Joe, why do I have an LLC? Why does that property in North Carolina is owned by an LLC? You have any idea?
No idea.
I didn't want to have to probate it in North Carolina. So Jeffrey set up an LLC and it owns the farm. Because it's an LLC, it's an intangible asset, so it's probatable in the state that he's domiciled in. And I don't have to go to North Carolina. When I told him, he goes, yeah, you're absolutely right. I totally forgot about that. But clients want to know all about probate. They all want to avoid probate, and I'll get into that later on. It's not a bad thing. It's not a good thing, but it's not a bad thing. They also want to know death taxes, and most important, which Jeff is going to go into later, how do I take my pension? What kind of distribution should I get? Should I take it all as a lump sum? Should I leave it at my employer and take an annuity for my life and my spouse's life? Should I take a joint survivor? Should I take a joint a 100%, 100%, or 100%, 50%? By that I mean if I take $100 a month, when I die, my wife gets 50%, or 100% and 25%. Jeffrey will go into those rules. But these are issues. We cover the areas of elder law, and I went through 11 different items. And I went through Social Security, estate planning, document preparation, Medicare, Medicaid, power of attorney, living wills, pensions, death taxes, probate, and title. So if we cover all these areas, I want you to go back to your college days. What majors in college cover retirement planning? And one other item, insurance. By that I mean life insurance, health insurance, disability insurance. So if we go back to college, what majors, what sciences, if you're going to talk about retirement planning, would it encompass in the business school or an MBA?
Economics.
What goes hand in hand with economics? Finance. They're all majors. What else? When you talk to a client,
Communications.
communication skills, excellent. Most people miss that. What else? I have clients come in my office. I started with nothing, and I'll leave with nothing. I have clients that are extremely wealthy. And in Philadelphia, the most wealthiest individuals are responsible for the foundations and their charitable gifts. And they say, my children have to make it on their own. So which college majors do you have to know even to talk to them? I cannot alienate a client. Philosophy, psychology. What's the client saying to you? I had a young kid. Jeffrey and I had a young kid on the phone yesterday. His father's probably worth $60, $70 million. The kid hates his father. And he says, I just want one of those properties. Just one. Am I going to get one of his properties? And the father has probably 20 beachfront homes and a phenomenal shore resort. One of the best. And I said, your father is a spendthrift on himself. Your father hurts himself. I think he told me he lives on $300 or $400 a week. And not one of his properties had a lien or a mortgage on it. It's right on the beach. And they're brand new homes. Do I understand them? No. But is it psychology? Yes. What else? What's the biggest thing today in retirement planning? Over 50% of marriages and in divorce. The biggest problem that we have, and it's an ethical problem. Can I do retirement planning? When I have two spouses, they both have children from other marriages. I'm sitting there. Can I counsel them? Can I give them my opinion? Or do I have to tell the husband or the wife to seek independent counsel? Anything else? We're lawyers. What else is? Now we've gave all the other majors. What other law school degrees? State and gift tax?
Tax.
Anything else? We have to know how to draft wills and trusts. The point I'm making here, we have 8 majors, 8 degrees. Is there anyone of the 500 plus people on the web or in this room that know all these areas? I don't. When you do retirement planning, and the theme I'm going to knock and repeat repeatedly today, is that you work as a team. I work with an insurance person. I normally work with a trust officer. I work with a CPA. I tell clients, or I tell the certified public accountants, one of the areas, they all want to make more money. They all get tired of doing tax returns. And they want to do planning. But the only way you do estate planning or you do retirement planning, you have to build up a mountain of documents. I have documents in my safe for the last 38 years. I moved to the building I'm in now in 1984. If you call 545-5800, you will trunk into my phone. Because I still have at least 1,000 wills I did prior to 1984. I'm still getting the estate work. I'm still getting the retirement work. And I tell CPAs, generate estate planning. The client trusts you more than anybody. The client may see me once or twice a year. He may talk to me every week. But the CPA is there. As part of his year-end review or her year-end review, I say, talk about retirement planning. And they most say, I'm on a yearly retainer. I don't want to do it. So I tell them, we talk about these areas. They know the client. They know the philosophy of the client. They know the psychology of the client. They know the disability insurance. But we work as a team when we do the retirement planning. I'm going to jump ahead a little bit. Why would I bring a trust officer in? And we're talking about middle income people. Let's step back 1 second. What is middle income? What's net worth? What do you think?
Well, I would say the annual income is around 50,000.
What do you think the net worth is?
The net worth, I would say around 100,000.
What do you think?
80,000 at this point.
What do you think net worth when they die? The average person, the middle class. Let me erase this and let's do some numbers so everybody can follow what we're talking about. Got a house. The middle income person owns a home or owns a condominium. What do you think it's worth? 300, 350, 400? So we're above your 400 already.
300.
Say 400,000, say 350. Most of them inherit something from their own parents. What would you say the savings would be? Marketable securities. The investment accounts.
100,000.
100,000, I agree with you. And they all have life insurance, 250, 300 from work. Let me digress a little bit. Would you say a banker is middle income?
Sure.
I would. I would say most attorneys are middle income. Then they have a retirement plan, say 600,000. You're talking about $1 million. For purposes of this exercise, I look upon middle income as somewhere from $1 million to 2.5. They have to plan their retirement. They have to worry about, will this be enough with Social Security that if I sell my house and move to Florida, buy a cheaper house, will I have enough to retire on and live a decent standard of living the way I'm living now? Most of these people will have people knock on the door, whether it's a cousin, whether it's a nephew, whether it's a neighbor. They want to get to this retirement money. And what does the person who knocks on the door, they want to buy an annuity. What's the reason to buy an annuity? The sole reason. Jeffrey just did one for a client. He was ready to buy $1 million annuity, and he asked us to do an actuarial analysis of it. At the end, we said, no way.
Higher interest rate.
What do you mean interest rate?
How much they get back on the annuity?
No. The reason he's referring it and recommending it, he gets anywhere from 6 to 8% off the top for that one product. He doesn't care whether it's the right item. He wants to get his hands on that $600,000. And I'm jumping ahead. Someone will call him to call your client, middle income, and these are the people they prey on. They'll say, I'm from so-and-so life insurance company. I'm not going to pick on anyone in particular today. Can I talk to you? Absolutely no. Phone goes down. I'm from this brokerage company. Can I talk to you about retirement planning? Absolutely no. Third person will call in. I want to show you how to avoid probate. Probate? You don't want to pay those probate expenses. You don't want your estate to be a public record. I will show you how to avoid probate by a living trust. his only or her reason for getting in there, they want to get to this retirement funds. Whether it's from FedEx, whether it's from UPS, most of these individuals have a lump sum coming in anywhere from $200,000 to $700,000. Is there any benefit of a living trust? Is it the right document for a middle income America? Will it give them any benefits? What's the cost of probate for $1 million estate? Couple $100? Sure. Does it save time? Absolutely no. Does it avoid probate if it's properly titled? Yes. 98% of the documents I've seen for middle income America, they're never properly titled. They will come in my office after death. Someone will come in with a great living trust with a bow. Great document. It's worthless because to avoid probate, you have to put the asset inside the trust. They're not going to put their home. They're not going to put their savings. The life insurance will be payable to the living trust. The only exceptions is in the state of Florida, and there's 1 or 2 other states. Every time I've seen it, the cost of drafting the living trust is usually 5 times the cost of probate. And we will never distribute assets to the beneficiaries until we get a closing letter from the state, and if IRS is involved, from the IRS. We have a newsletter for those of you who want to check our website on our living trust scams or the right document. And I've seen it time and time again. And it's usually by attorney or by people who are not attorneys will be recommending it to get in. I know a friend of mine was drafting living trusts, a lot of them. And I said, what's the benefit? He goes, the client wants it. What am I supposed to say? No? And I looked at him. I said, you say no. You have to get through or go through the exercise. But on an estate of $1 million to $2.5 million, you need a team of advisors. In this instance, I'm jumping ahead of just a little bit. You're going to have $1 million go to children if both parents are dead. If the children, I'm going to use a number, say 30 to 40. If you have 1 child or 2 children, would you set up a trust for them? Retirement planning. That's what the clients want to know. Should I give it to them outright? Should I give $1 million to a son who's 35, married, with a child? Would you? The client wants to know. You're a general practitioner. You're getting into this area. The client knocks on the door. And we're going through these sciences. And should I set up a trust fund? Or should I give it to my son outright? What's advantages and disadvantages? What do you think? You're in this situation now. You come in my office. How many children do you have? 2? 1. And it's 30 years from now. Would you leave your son $1.5 million?
Sure.
Outright?
Outright.
Would you?
Yes.
Okay. What's the percentage of divorces?
50% or over.
Okay, so everyone understands this. Is an inheritance marital property subject to equitable distribution?
Sure. Yes.
Not in Pennsylvania.
Not in Pennsylvania.
But when does it become marital property? You convert it. They get the $1.5 million or the $1 million. They put it in joint names. You go to your wife and say, honey, I'm keeping it in my sole name. Or that sure place that we want, or that new home, I'm putting it in my name. You won't stay married. So most inheritance, even though it's originally non-marital and not subject to equitable distribution, becomes marital. So in my opinion, I set up trusts because people get divorced at 30, 40, 50, and the new age is 60, and it's even going to 70. It's those catch years. And we have written many times, and there's many articles on our website that tell parents, how do you protect inheritances? How do you protect your children? Most children believe they're infallible. Most children believe when they buy that franchise, it's going to be profitable. Most children believe when they buy that stocks or bonds, it's profitable. And even on an estate this size, I will not recommend myself as trustee. I usually like an impartial, neutral, corporate fiduciary. I usually like a team on there with the CPA, but I usually like a professional money manager. For those of you who want to give the middle income clients some advice, the biggest problem that I see today, especially in protecting inheritances, protecting this retirement money that parents do not spend on themselves so their children do receive an inheritance, is theft. We've repeatedly in my office have seen individuals steal from their own siblings, from their own children, from their own parents. And I'm not talking $20,000 or $30,000. I've seen 7 figures theft because of drugs, gambling, or women, or a combination of all three. So I usually like a professional corporate fiduciary. Clients are going to say it's going to cost money. You can't afford not to spend the money. You will save money. We've handled one recently where a brother stole over $1 million from his younger brother. He had a drug problem and a gambling problem. And I usually like the money professionally managed. But to reiterate, we started with a living trust. They're going to say, as part of my estate planning package, as part of my retirement planning, should I set up a trust? I want to keep things private. I want it confidential. Yes, your full estate will not be part of your probatable estate. But in every state in the United States, a living trust is includable for inheritance tax purposes. And we have to attach the living trust to the inheritance tax return. That doesn't go to Philadelphia County, doesn't go to Montgomery County, doesn't go to the local county, but does go to the state. And it is a public record. So there is no secrecy, there is no confidentiality. With the ethics part, in retirement planning, sometimes you do have an ethical problem. And if the clients do not agree before they come into my office of how they're going to distribute the assets, I do have to recuse myself. Or I do have to say, I can represent one of you. If they come in as a unit, and the Code of Ethics does allow husband and wife to be treated as one, I can represent both in drafting documents. But if I see a conflict and they're starting to disagree in front of me, I cannot and will not represent both. It will come back to haunt me later on. Anybody have any questions on the team? So, once again, do not try to control the client. For those of you who are looking for someone who knows it all, whether he's a certified financial planner, whether it's an attorney, whether it's a CPA, there is nobody out there. We do estate work a day in and day out. We do retirement work day in and day out. I know of no one who's an expert in all areas. When they try to, they step on my toes, and there's usually friction. And if we disagree as a team, the clients normally will not use any of us. So I try to get unison between or among the professionals to do a retirement plan for the client. We're talking about middle income. So you have a client here, say with $1 million to $2 million estate. He's concerned, how am I going to retire? I will have Social Security, and then we have to work on an actuarial analysis. Jeffrey will many times will take the $1 million, say it's for the spouse or for them, and do a life analysis on it if they're taking out $3,000 or $4,000 a month. Jeffrey will give them their Social Security monthly benefits, and we say, what will you need? Are you going to stay in this house? Say the house is worth $500. Are you planning to stay there? Are you planning to move to a lesser house? If you have a house and a house in the mountains that are worth one that's worth $100,000, are you going to liquidate one? How much have you spent for tuition for your children over the last few years? So how much will you save? Also, when I'm talking about trustees, say I'm setting up a trust for a spouse. I will try to be the buffer, and I will bring in the team of the corporate fiduciary with the spouse, because I'm giving you pure practical advice now. I don't want the children to control the spouse. I'll repeat that. I will do everything within my power that the children not control the spouse. And it happens day in and day out. I've had many clients say to me, Joe, if I don't do it, I will not see my grandchildren. Or I'll see my grandchildren once a month rather than 4 times a month. I've had instances where they're supposed to visit the parents. The visits got canceled. They're supposed to fly in during the holidays. The visit got canceled. So when you're looking for a team to control this $1 million, think about the practical ramifications. Think about your spouse, that you don't want one child taking advantage of the spouse. And I've seen it time and time again. We have a drop tomorrow. One of the children needs $50,000 from a trust, and we have projections. But the spouse doesn't know what to do. If she doesn't take $50,000 from her trust fund, the daughter and the son-in-law may lose their home for whatever reason. And I found it amusing. She's willing to agree to making the distribution. And I said, part of the terms, I said, we pay the bills directly. We pay the property taxes, we pay the mortgage, and all of a sudden they balked. Why? Is the money owed? I said, give me the outstanding balance and we'll send the money directly from the trust company. I don't have a problem with it. And they balked. I sent the documents over yesterday. I said, if you want to close Thursday, get everything to me by the time I leave for New York. I don't have it. The point I'm trying to make is that a lot of times when you're doing this retirement planning, be practical. Have a little street smarts and understand what happens when a mother does not need that pressure, or a father does not need that pressure. Okay? Let's proceed with the documents. The first document on retirement planning that everybody needs is a power of attorney. I said earlier that most of the clients will be disabled before they die. Most of the clients cannot take care of themselves over the last 2 or 3 years. And clients are concerned about that. They want to be positive of health insurance. They want to be positive that they most of them want to be rest assured that they can live in their house. And someone has to come in to take care of them physically, and someone has to take care of their financial affairs. In my own situation, I have never taken care of someone physically. I've taken care of quite a few people on their financial affairs. What do I need to do that? You need a power of attorney. Power of attorneys are usually durable. By that I mean it states right inside the document that if I become disabled, the document is irrevocable. There's case law out there in many states that if I become disabled, since I cannot revoke the document, it's automatically revoked. I'll repeat that. In some states, the document states, the law states, that if I become disabled, I cannot revoke the document. So it's automatically revoked. If it's a durable power of attorney, it becomes irrevocable if I'm disabled. Depending on the client, a power of attorney is a strong document. In Pennsylvania, they have a task force right now trying to rework all the laws on power of attorneys. If you are an executor, you have to do an accounting. With a power of attorney, you do not. And we're talking about theft a couple minutes ago. Someone who will only steal from you if you trust them implicitly. I'll repeat that. You will never appoint a stranger as your fiduciary. So someone only has the means and capability of stealing from you if you trust them implicitly. So a power of attorney is a strong document. You can have a limited and you can have a general. If someone is not of old age and close to disability, I will have a springing power of attorney. By springing, I mean it springs into life if 2 doctors will sign a letter that I'm physically incapable of handling my financial affairs. I'll repeat that. It springs into life if 2 doctors will state that I'm incapable of handling my financial affairs. And you just attach them to the power. And it states, the document also states you can reverse it. 2 doctors can state that now I am financially capable, mentally capable of handling my financial affairs. So then the power of attorney becomes void or powerless. In a general power of attorney, if you want to restrict some of the general powers that are in the state statute, you have to state it right in the document. You normally have, they can file tax returns, renounce fiduciary positions, like just say, I'm appointed executor of my father's estate. If Jeffrey has my power, he can state that I don't want to become executor. Where you have to be careful is gifts. Most general power of attorneys allow the attorney to make unlimited gifts to anybody, including himself and herself. I will usually talk to the client in detail on the gift section. Is it limited to the annual exclusion, which is $13,000 a year? Or is it unlimited? Is it limited to a certain class of individuals, such as children or grandchildren and his or her spouses? You have to review that with the client. You may want to also restrict the changing of plan beneficiaries. With the day and age that we're in, I don't want Jeffrey to be able to change my pension beneficiary from a trust that will benefit him, Jeffrey, and my daughter to himself. Who should be the guardian? Does he have the power to put me in a nursing home? Or can he only put me in a nursing home if I cannot live inside my house with 24/7 help? You have to talk to clients. We get into the communication skills, as you said. We have to find out what the client wants. Most clients want to live at home. Most clients can live at home with 24/7 help. And I say to clients many times it's much cheaper to live at home and have someone move in with you than it is to put him or her in a nursing home. Look at the costs. They want to know about long-term care. I say price it out. Like I had someone today call me about converting a term policy to a whole life. And most people don't know the questions to ask. And now I'm above 60, I have to review these items. I said, what will it cost to convert it to whole life? He said, you're going from $1,500 to $12,400. I said, what if I wait a year? Well, there may not be offer. I said, what if I was a year older? What would it cost me if I do it next year? $12,900. I said, so I'm going to spend an extra $12,000 to save $500? Something's wrong. I said, I'll think about it next year. No, but I said, ma'am, please. But these are numbers. Most people don't know the questions to ask. Same with a power of attorney. I constantly tell people you absolutely need a power of attorney when you reach a certain age. Review it, appoint a group of people. You also, one of the items that we go into constantly is if the person's far away, it may not be practical. We had a client in the other day, his son was in Texas. It's impractical to have him or her as the attorney. If there's 2 people or 3 people, can 2 out of 3 work? Always have a replacement inside the document. The second item would be a living will. As part of retirement planning, you need a document, a living will. Most clients will want to take it off the web. I've seen very, very, very few people draft a simple will, draft a power of attorney, draft a living will 100% right. It's usually 85% right. Usually the 5 or 10% that's wrong will come back to haunt you. We had one recently where they appointed an executor, they forgot to say without bond. The bond's expensive. It's very expensive. But they took it off the web, they forgot to type in those words. We have people who don't get it properly notarized. And it's so inconvenient. But they don't know the ramification. What if one child dies? They don't know the difference between per stirpes and per capita. They're just not educated in that area. So I usually tell clients it's cheaper to have it professionally done, but communicate with the client constantly about these different areas. In the living will, most of them are scared. And when I have them check the blocks or initial the blocks, they say, I want water. I need anesthesia. I need this. I need that. And I say, you're in a no-code, irreversible, death time situation without pain. This is the only way you will die if you put your initials within these blocks. I'll repeat that. In a living will, they have to be in an irreversible death time situation without pain. You will usually die if the doctor withholds certain medicine, certain items, but you're not in pain. When you deal with people, you say you need the most practical child. You don't need an emotional child. Most clients will say, especially middle income people, will say, I want my oldest son or daughter. It doesn't have to work that way. Your oldest son or daughter may be the most emotional. And since we're dealing with a professional audience, we make more decisions in a morning than many people make in the entire year. I'll repeat that. We make more decisions in one morning than many people make in the entire year. So you have to look at the pluses, you have to look at the minuses in a living will, and the decision has to be made. And it has to be an objective, pragmatic decision. And you doesn't have to be the oldest child, doesn't have to be all the I don't want all the children. You're never going to get 5, 4, 3 children to agree, no matter what happens. When you're doing retirement planning and the patriarch of the family is gone, that's when the family falls apart. I've seen many families, as long as the father or the mother was around, there was never an issue. But when the father and the mother died, that's when the family splintered. All those fights that the children had as children, surfaced to the top. And I've seen a lot of money spent on fights over minor items. Okay, we went through some of the documents. We went through a living will and the general power of attorney. The last thing is the will. What do? Should someone with $1 million estate give it outright? Should they give $700,000 to a spouse outright? Especially if they're second children from another marriage. Since we're dealing with issues and we're dealing with war stories, I try to avoid an outright inheritance. I've seen, once again, when the father dies and it gets wind that the wife just received or the husband just received $1 million, if it's the husband, all the ladies in Florida are going to be knocking on the door with platters. If it's a wife, I'm going to get every neighbor, every nephew, everyone who's a financial consultant coming in to invest the money. Besides being in mourning, the person does not know how to make a prudent decision. So I usually like a team of fiduciaries. By that I mean, I usually like a trust, especially if there's children from other marriages. Most husbands or wives have no problem supporting the spouse during his or her lifetime. But when she dies, they want to be positive the money's left according to the way he or she wants it. I'll repeat that. Just say I left $1 million to my wife. I've been married, I got 2 children from a prior marriage, she has 2 children. I have no problem giving my wife all the income, as much of the principal as she needs for her health, welfare, and maintenance. But when she dies, I want to be positive that I dictate what happens to that money. So, once again, we're talking about $1 million. I have a previous marriage, I got 2 children. And she has 2 children. I've been with my second wife 20 years. I'm more than willing to put that money in trust and say she gets all the income, monthly or quarterly. She gets as much of the principal as she needs for her health, welfare, and maintenance. But when she dies, I want to be positive that that money is split evenly between my children and her children, or any variation of the same. That is called a Q-tip trust. It's called a qualified terminal interest property trust. It was brought about in the late 80s because I think it's more than 50% of Congress are in their second marriages, and it qualifies for the marital deduction. To keep you a little confused, the marital deduction for federal states, if I give it to my wife or my spouse, I get 100% deduction. I don't care if I have $1 million or 5 million or 10 million. As long as my wife, spouse, can touch it, feel it, use it, I get a deduction. There's no death taxes. The Q-tip is an exception because she or he cannot go inside the trust and say it's my money. I want to use it. And it came about by a fiction of Congress around 20 years ago. So it's a Q-tip trust. She gets the income. She gets as much of the principal as she needs for health, welfare, and maintenance. But when she dies, I dictate where it goes. And for most second marriages, and because 50% of marriages and in divorce, these are issues that I have. These are ethical issues. And I cannot tell the client or tell the wife it's going in trust, but he gets it. I let them make that decision. It also protects each spouse from him or herself. I've seen that. I was joking with a guy from my Florida condo, and he has this woman living with him like 2 days after his wife died. And I was joking when I'm teasing him at the pool. And he says, Joe, he goes, I brought her in. We're friends. She cleans, she cooks, and I pay her. But it stopped other ladies from calling me wanting to move in. And this guy's in his late 80s. He said, you don't know how many calls I got. He said, by having her move in, they think I'm with her. So I'm protecting from myself. But I also want to protect each spouse from another bad marriage, that everything that I earned and saved and created will go to somebody else. Similar to children with the divorces, the commingling. I know someone back in Philadelphia, his wife died. He was ready to get married. They bought a $2 million home on the beach. They were moving. And he got pancreatic cancer and died in 3 weeks. But the house was titled in joint names. His children are not talking. They're devastated. But it was no undue influence. There was no coercion. There was no force. There was no fraud. He thought he was going to marry her. They bought a big house. And then he caught cancer and died in a couple weeks. But it happens. And this guy was a professional. So what I'm saying is, when we do retirement planning, we have to protect one another. And you don't want to repeat war stories constantly. But these are the practical facts. When you've been around as long as I've been around, you know the retirement planning and the estate planning and the downside. I'm all for trust. You'll hear me say it repeatedly. I believe everyone has to be protected. I have no problem, no matter what the age, to allow the children to reach their principal eventually. By that I mean, what I usually do is start at the death, where they can walk in and say, give me 20%. Every 5 years thereafter, they can walk in and get another 20%. Or whether that's a third, or 25% at each instance. But what I'm looking for is, if they make a mistake, they can make another mistake. And it's our job to educate the client. If the client says to me, I want an outright, I'll do it. But it's rare in today's world that people get outright inheritances. There's too many ramifications. What do you do? The client says, I don't want to leave something to one son. He's a druggie. Delete him from the will? What do you say? What would you do? Would you say, I'm intentionally not leaving anything to my son, Alex? Or would you just take him out of the will?
Well, I think the client would have that option to take one of his offspring out of his will. And I don't think it's ethically wrong for him to do that.
I tell clients it's their assets. But I will usually state inside the document that I intentionally left Alex out of this will. It's not an oversight. You don't want someone to attack you to say you forgot to put Alex in there. Happens. So I usually put a clause at the end that I intentionally left Alex out of my will for personal reasons, or put some story in there why I left him out. Many times when they reach old age, or elderly people, as part of the retirement planning, they want to do something now. They're trying to do something for their grandchildren. Jeffrey will touch briefly on 529 plans, which are college for the grandchildren, where you can double, triple up on the contribution, and if they want to leave real estate to a child. You can either do it through a 2503 trust. A uniform gifts or transfer to minor cannot own real estate. I'll repeat that. A uniform gifts to minors cannot own real estate. So we have to either do a revocable trust or a 2503C trust. A big story for middle income people, and we get it repeatedly, is special needs trust. Special needs, and I had someone call me yesterday. The guy has money, and he said, I need to do something for my daughter. She has $500,000 in her name I put away for her, but Joe, there's problems. And I said, John, you have to do something. Not for the $500,000, I'm not worried about the $500,000, but the medical bills when you're gone. They can eat you alive. You may have to have her declared, be eligible for Medicaid. So it's only through a special needs trust that you can care for a disabled beneficiary. You do have clients who will say, I have 3 children, I'll leave everything to 2, and the 2 children will take care of the 3rd. I normally say absolutely no. There is something that was put in by IRS called a special needs trust. I'll put money away for that special needs child and say it can be only used if and only if all federal, state, and local funds have been exhausted. And if the state ever challenges it, this trust is null and void, and it should revert back to the other 2 children. This is time and tested. It's not a tax loophole. It's not a gimmick. It's allowable by the states. It's called a special needs trust. So if there is a disabled child, the money's put into a trust and said it can be only used for special circumstances after all federal, state, and local funds have been exhausted. And you normally put a clause in there, if the state ever challenges it, this trust is null and void and should revert to my other 2 children. We have used these. They've been honored repeatedly, but you need to have someone draft them who's been around, who understands the different sections. For life insurance and other items, for tangible items, I will usually leave them by a personal memorandum, and I'll put in the will, please honor the item. Many times when you're doing documents for people who are normally ready to retire, they say, I'm going to leave the items outright. Or IRS and the state will never know I have them, I don't want them taxed. Children won't fight over the $1 million. They'll fight over tangible items, the rings, the watches, the toys, the baseball card collection, the diamonds. So I usually tell the clients to be specific. Leave them by a personal memorandum. That's what you'll attach to the will. One last item before Jeffrey gets up here is titling of assets. Another war story where that families fall apart is when someone is elderly. Someone has to pay the bills. So normally, they'll go down to the bank. The bank teller will say, open up a joint account. They'll say, no, you need a power of attorney. No, you need a joint account. And I've seen many instances where they have a savings account, say $100,000. It's in my name or my father's name. There's major problems with that. First, what happens if I die? My father put $100,000 in my name or his name. We either can sign. The account is to pay the bills. If I die first, half of it's includable in my estate. There's no way around it, and I've gone back to fathers and say, we need 6%. No way, it's my money, and they're fighting. You will be taxed. Secondly, when my father dies, that's non-probatable assets, I get it automatically. I own the entire account. It passes outside the will. And I've seen many, many situations where families will break up over it because my wife will say, your dad intended you to receive that money. You're the one that's been taking them to the hospital. You're the one that's been buying them groceries. You're the one that's been taking them to the doctors. And absolutely, unless it's a bank of convenience, it's my money. No one can fight it. It doesn't pass according to the will. You have to tell the bank teller you need that power of attorney we spoke about. You have to give it to them. It's going to have to bypass the teller. She's not going to honor it. It has to get approved by counsel. And they do have a card in their drawer that gives power of attorney. But 98% of the accounts will come joint. So when you review the assets with your client, review title. Review the bank accounts. That's what the power of attorney is for. A couple other ethical issues. Make sure you're competent in this area. Make sure you bring the team in. Make sure you review a lot of the other areas. And talk to everybody and make sure you're all on the same page. One last issue is business succession. For those middle-class clients who have a business, make sure a plan is in effect, whether it's a buy-sell. Most clients will want all their children to become owners of the business. Talk to your children. One field I feel is overlooked in retirement planning and estate planning is psychology. It'd be nice to sit down with a psychologist or someone trained and talk about the estate. Talk about who's taken over the business. If John's been working at the business for 20 years, do not give it to all your children. It doesn't work. Start talking about the assets. What does each child want? In Florida, I joke every time an ambulance goes by, a condo goes up for sale. 3 children don't want it. If a child does not like the beach, do not give the beach property to all the children. Talk to your children what they want. Many children will take a lesser amount if they get the business. And it's only fair. I mean, what amazes me that certain clients have children that I always saw as a child. Now they're 45, 50. And their father's in their late 70s, and there's nothing in effect for the child to take the business over. And the other children never set foot in the business. But you have to talk about it, and you have to effectuate what you want. So before Jeffrey gets on, once again, everything we spoke about is taxes, documents, and welfare and security. That's what you're looking for your child 30 years from now. You're looking for your clients who are calling you. You're always worried about, everyone is worried about their own security. And the last couple of years, they'll sit there with $1 million in that checking account and not even worried about it. They're worried about living. They're not worried about their finances. You can talk to a client in a very practical terms when it's not imminent, when they're in their 60s. And you can set up a proper plan. But if there's issues, let them go back. We had one in last week. It was 2 professionals, 2 professors, no children. And I said to them, you're leaving, it was a couple $1 million. But they were middle-class people. They worked for their money. And I said, you're leaving it to nephews and nieces. How often do you see them? They said, once in the last 10 years. I said, why don't you do something charitable for most of it? I mean, why don't you set up a chair at where you've taught for the last 30 years? Or set up a foundation that you can give away scholarships for what you want. They said, we never thought. I said, it's your money. Do what you want. It's your money. Do what you want with your money. I said, you can leave something to your nieces and nephews. I said, if you left them $50,000, would they be happy? He said they would be ecstatic. But I said, when was the last time you saw these people? He said, 5 of them we have not seen for at least 10 years. So when you talk about this, talk to your client, communication skills. Everything with this client went on hold because they're giving us some serious thought. I said, do what you want, and when you do these things, especially when it comes to charitable, you can control the charity before you give the money. You can't control it once the money's over. If I have a plan, I can control the charity as I stipulate it in the document when I make the gift. We have one right now. You have to be at the school for at least 3 years without financial aid to be eligible. Why'd I do it? Because it bothered my son that kids were dropping out because their brother went to college, their sister went to college, or their father got laid off. They had to drop out of school. So I said, instead of someone brand new or bringing someone in to play ball, give it to a child who needs the money, who have already placed money into that school to be educated. Someone told me many years ago, and I've never forgotten, that you can control the charity before you give the money, and they're not going to turn the money down. Or you don't want to be that one university that spends, it's in the millions on their landscaping each year because the president is in the landscaping. Do you want it for the general fund? Do you want it for a stone building going up at this university? I don't. I want it to educate the people. Okay, I'll be on to close up, and thank you. If anyone has any questions, just email them. If you have any questions after the seminar is over, just email them at joe@pizzula.com or to Lawline, and I'll answer it. Thank you.
Hello, I'm Jeff Pizzula. I'm here to talk about the assets that you're going to use to end up paying for your retirement, what you're going to end up using for the last couple of years. What I'll be talking about is Social Security and the pension planning, and what choices you can make, what you can do now in your 20s, your 30s, your 40s to make sure you have enough money, and what you can end up doing in different steps of the way, how much money you should take, how much money you shouldn't end up getting, or what type of distribution option you should take, and those types of decisions. So first I want to talk about the Social Security. Just a quick summary. Social Security, most people, when they think about it, they think about retirement, they think about the general Social Security, with the Social Security insurance for poor and needy. What I'm going to end up talking about is it's a safety net for the retired, the disabled, Medicare, which provides planning, health insurance to elderly people, and benefits that'll end up helping the family of those people and survivors of those people if the main breadwinner ends up passing away. What Social Security is, first off, it's a pay-as-you-go system. By that, what I mean is there's two types of systems that you can have. One is a pay-as-you-go or an account system. A pay-as-you-go system is one where me as a current worker, I end up paying for the current retirees. When I retire, the future workers will be paying for mine. This has fueled a lot of the problems that we've had in the last couple, or a lot of the speculation over the last 10, 15 years over whether I'm personally going to end up getting Social Security. And that's an issue. It comes into a bunch of factors of whether the economy keeps growing, it's whether what rules they change, do they end up changing the ages, what ends up happening with that. So that's actually one person, someone more my age, has to consider, is this something that I can necessarily rely on, or should I be building up other assets outside of Social Security so if it dries up, I have my own sort of Social Security. The other system is which it's been talked about in years, is an account system. What an account system would be, that would be more like a defined contribution plan. I'll discuss them later. An account system which has been proposed, it hasn't gone through or anything, it's been talked about for the last 10, 15 years. It's one of the options on the table, which would be if I end up putting my money into the taxes that I pay, that ends up going into an account. and eventually they treat it as if it grows, and then I receive what I paid back. The only issue with that is you're dealing with inflation, you're dealing with growth. So what I might have put in, let's say, if I was older, let's say I put something in the 50s, the couple $100 I might have put in might not be enough to sustain me. And that's the reason why they've been using the pay-as-you-go system, is to keep the funding, considering you have a difference in the two, between when you're older and when you're younger. When you're older, the money you put in, the interest and the investment might not have kept up. So so the second thing is, so generally what Social Security is, it's a safety net. It's to provide if you didn't have other assets, you have something that you at least will not fall below a certain level of income. That doesn't necessarily mean you're going to live a comfortable life. It just means it provides that security, that basic level of security. So the first thing is, who's eligible for Social Security? So first, United States citizens, that's pretty self-evident what that would be. There's U.S. nationals, which is most of the time you won't be dealing with that. That's people who aren't citizens but have nationality status they're usually related some external territories of the United States. And then the third one, which I think in recent years is something, especially as the world's becoming more international, is there's a qualified aliens can use it. So if it's a long-term or legal residence in the United States, there's certain hoops that if they jump through, they have the option of receiving Social Security. The second requirement mainly that's needed, other than the citizenship requirement or the status requirement, would be work credits. You don't want someone coming in the system, let's say they haven't put anything into the system, they've worked maybe a day in their life, and all of a sudden you don't want someone hasn't put in, you don't want them to get anything out. So what they have is, it's called the work credit system. What it is you get 1 credit for each quarter that you work. To get credit for that quarter, you have to have earned $11.60 in that quarter. So if you've earned less than that, it doesn't count. If you've earned more, it does count. What they've done recently, I think it was 1978, they treated it more on a 4-quarter system. So if you've earned $46.40 within 4 quarters, doesn't matter whether you earned them all in the first 10 days or you earned them the whole time, you end up getting credited 4 credits. Where these credits are important, for retirement plans, you're required to have 40 credits, or else you can't, so that's 10 years, quarters, you're required to have 10 years of work credits to be eligible for Social Security. Another area that it's important is with disability. Starting around 31, you only need about 20 credits. But as you get slowly closer to retirement age, you need the 40 credits to receive your disability. One key factor on this is 20 of those credits have to have been earned in the last 10 years. So if you have someone that's worked 20 years ago, all of a sudden disabled, they're not going to end up receiving any of their benefits. There is an exception if you're blind or if the person is blind, but generally that's one thing that's important. The third benefit, where this plays in, is with Medicare. If you have less than 30 credits or your spouse has less than 30 credits, you end up having to pay full value for what's called the Part A insurance. I'll discuss that later. If you end up having between 30 and 39 credits, then you end up getting a discounted, it's about $220. But if you end up receiving, with the new healthcare legislation, if you have 40 credits, by being eligible for retirement, it makes you eligible for free of Part A, which is its inpatient coverage. Then within each area, there's different specific requirements within the specific areas. So the first question is, most people, it seems completely like voodoo. What do you do? How is this benefit calculated? Is this benefit calculated? Do they just pick a number? Generally what happens is they take your 35 years highest income and they fill it in a rubric, and they have an indexed amount. What this indexed amount does is it factors in numerous data on what's necessary for someone in this field and having that amount of money or that amount of income. The other key point on this is if you've made more than 113,000, or if you've made more than what's called the wage limitation, if you've made more than that, then for those particular years, only the wage limitation's in there. So for instance, if you've made, let's say, $500,000 for that year, you end up for 2013, the wage limitation is $113,700. So for that year, you only get credited for $113,700. That actually, so you don't end up getting the extra benefit. There are, in the pension planning, you can get into, I can discuss that later once I discuss that, but there's ways of receiving a benefit to make up for the fact that you can't receive benefits over 113,000 or the wage limit. So just to keep this in perspective, how much money Social Security provides you, on average in April 2013, which is the most recent data period, $1,267 was the average monthly benefit. I would assume this would end up being someone that would have had maybe 80,000, 100,000 of income, and you're going from that amount to roughly 15,000 of income a year. So clearly, Social Security, it's a bottom safety net, but it's not going to enable you to live a comfortable life. It's not going to enable you to move down to Florida. It's not going to be able to, you might be scrapping for payments, especially with other expenses that you might be running into. So the next thing people always ask is, what ages can I retire? When can I retire? Can I retire at 55? Can I retire at 50? When am I eligible to start taking it? So with that, the first age that you can retire would be 62. Then at 62, you end up having a reduced benefit. But as you get slowly closer to what's called full retirement age, then you end up receiving the full benefit. So when they plug in the 35 years in those numbers, it comes out with a general number. That's the number that you would receive in the full benefit. So then each month you go earlier, it's discounted, and then each month later, you end up having higher amounts. So the normal retirement age, if your birthday is, or if your age is, if you were born in 1937 or before, you're going to have the traditional 65-year age. If you're born 1960 or after, then you're going to have the 67 age. So this is one thing, and within that, it ends up increasing slowly through that. This comes down to what I was saying before. They're slowly, to make sure to try to have Social Security be something that's longevity, something that will last, that I can actually receive some. It might even go up to 80, or it might even, the age as people live longer. I might not be able to rely on receiving it at 67. I might end up having to I might not be able to have this to 72, and let's say I need to retire at 65 because my functionality is gone. I need something in between that. So that's one thing or I might have to take early. Another adjustment that you end up running into with Social Security is if you continue working, because you can end up receiving the benefits, but if you don't continue working, or if you continue working, there's a reduced benefit. So if I end up receiving, so I'm born after 1960, so if I end up receiving my benefits at 62, and I continue to work, $1 of every $2 that you make over 15 in 2013 over 15,120. We actually just had this decision. My dad was, because he just turned 62, he was wondering whether to take or not. And one of the issues is, if you're making over that 15,000, you start reducing your benefits. What the issue with that is, so let's say you're making with an average benefit of $12.67. So an average benefit of maybe 15,000 a year, maybe 20, 25, just to give you extra, for the fun of it. If you end up making $60,000 in that year, or let's say you're making $80,000, so you have 60,000, 30,000 of that, which is above the 15,000, gets reduced out of your benefit. What's that mean? You're not really receiving it. Even though you're taking early, you're not actually receiving a benefit. So it's one consideration to figure in and when to take it. If you're at retirement age or above retirement age, then 1 out of every $3 over 40,080 for 2013 is reduced. So what this means is, if let's say I'm making $100,000 a year, so 60 would be above that, I would end up reducing my benefit by $20,000. So that's another situation where it might be better if I'm earning a significant amount of money and I'm still able to work. It might be beneficial for me to continue to work at that older age. If I want to retire early and I have other assets, that's a different story, and I'm not relying on it. But that's one thing that you have to consider is, if you continue working, your benefits are going to be reduced. The other adjustment you end up running into is the cost of living adjustment. So Social Security is adjusted for the Consumer Price Index, which it tracks inflation over the years. And recently, the 2013 benefits have been increased by 1.7%, which is modest for what you're. What the idea is that it can keep up with the expenses. So, although you're receiving $1,200 on average, that doesn't necessarily mean that you're receiving $1,200 forever. You're receiving $1,200, and that increases through the years, at least to stay somewhat in pace with Social Security. So, after considering these adjustments, you end up running into the next question is, which I was hinting to early. Do I want to take early? Do I want to take at 65? Do I want to take at 67? Should I take later? What are the considerations on that? So, first off, if you end up taking early, what happens using my age, full retirement age, so 67, every month that it goes back, on average, every month it goes back, a fraction of a percent is subtracted from your monthly payment, the monthly payment that you'd receive at the full value. So this can end up being a discount. Let's say my monthly payment would normally be $2,000. So this can knock 20 to 30% off my monthly payment. That ends up, it might not sound like a lot, but 20 to 30% off of my $2,000 is $400 to $600 a year. When I'm making on average $24,000 a year, and I've just had about $7,200 knocked off because I took it early, that might be a situation where it becomes, push comes to shove, I might actually need that extra couple $1,000s. The second consideration would be for the delayed retirement. The benefit of delayed retirement, so the benefit of the early retirement is you receive it earlier, you're guaranteed to get the payment. So if for some reason the system runs dry, or for some reason you have poor health, you end up receiving those. For the other option outside, you can take the normal benefit, which for me it would start at 67, and I'd receive that until my death. The third option is to have a delayed retirement. So the benefits of delayed retirement, so that would mean me receiving it after 67, would be you end up receiving what's called the delayed retirement credit. Delayed retirement credit for the different age, it depends on the different years, year of birth, starts at around 5%, and as you get above to, I believe it's 60 or 50, I forget the exact date, you end up getting an 88% increase for every year, or it's, you get on average you get 8% a year increase for every year that I end up holding off on receiving my payment from the full retirement age, so 67, until my 70th birthday. After my 70th birthday, I don't receive this credit anymore. Part of what that's to account for is the fact that I would be receiving inflation on that, I would end up receiving investment income on that, and then the other major factor is, so from 67 to 70, I'm not receiving 3 years of payments. So it's, using my 2000 again, I wouldn't be receiving 24 each year, or I wouldn't be receiving $72,000. So how they account for that is they give me an extra percent every year to make up for that. The other thing that delayed retirement, and this is one thing that also comes into play with pensions too, is considering they take your 35 highest years. So let's say my first couple of years working, I was a dishwasher. That was my first job. So your first year, you're a dishwasher. Or your first couple of years out, you were doing some sort of apprenticeship. Something where maybe you were making only $10,000 a year. You're above the $4,000, so you end up getting credits for it. But you're not making it wouldn't significantly increase your payments. What ends up happening is, if you end up working those extra couple years, two things happen. If you're making a significant amount of money, yeah, you're foregoing $24,000, but if you're making $150,000, $200,000, you're also increasing your net worth by the $150,000, $200,000, which helps increase, and that might provide other assets, which is important considering from the amounts in here, it might not be beneficial to rely on this, the Social Security. And what ends up happening is that the higher amounts end up getting substituted in for lower amounts, which will raise, so my $2,000 might get raised up to $2,100. Doesn't sound like a lot, but over the years, it might add, or if you're in a situation where you need the extra funds, $1,000, $2,000 might make a big difference. Now, the question is, I guess, when would what considerations would you have to file at one time and the other time? Some considerations might be health. What's your general health? If you're terminally ill, probably be better to take earlier so you actually receive the payments because you're not going to receive them after your death. Lifestyle. Do you know what your lifestyle is? Are you smoking, drinking, have horrible recreational habits? Are you eating donuts and lard every day? It depends on or are you eating salads? Are you going to the gym? It depends on what you're doing. And that also comes out to do you actually need the extra money? Do you have a low income lifestyle, or not a low income lifestyle, but do you have a low maintenance lifestyle where you don't need the money till later and you can push it off? Another key factor would be what your other sources of funds are. As we were saying, as has been alluded to before, the majority of your funds come from, you do get some from the Social Security, but the majority of your payments might come from other assets, such as pensions, savings accounts, investments. You might have dividends off of those investments, purchased annuities. There's different factors that might hit on that one for whether you want to retire early. And the last one is just complete personal preference. Some people want their money up front. Some people would rather wait and save off for the future. So those are the couple factors that you have to consider, and you have to look at each person's individual plan. The second benefit that I'll be talking about is the disability benefit. So most people might think, all right, I probably won't have that many disabled clients, I won't have this. Factor from the website was for every 20-year-old that enters the workforce, 3 out of every 10 will be disabled by time they fit full retirement age. So if you have a practice and over the lifetime of the practice, you have 200, 300 clients, you're going to end up running into 60 to 90 different cases of where you're going to have to know the disability rules, or where you're going to have to point them in the right direction or point them this way or that way. So one key about disability, it only covers permanent disability. It doesn't cover partial disability, and it doesn't cover short-term disability. You have to meet the definition of what disability means. Disability, what it means is you can't perform the work that you had been performing. With adjustments, you can't perform this because of this medical condition. And going on the permanent factor, you end up having the disability has either lasted or is expected to last more than 12 months, or it'll result in death, which is more than 12 months. So the other thing it also has is if you think you might be disabled, or if you think someone might be disabled, there's a bunch of listed disabilities. It's Part A and Part B, or Type A and Type B, which would be like musculoskeletal type diseases, sense and speech issues, cardiovascular issues, skin disorders. This is something, it's something that might help someone, especially if someone won't be able to work again. It'll provide them that extra funds. This continues until you can work on a regular basis. The amount of benefits that are usually received for disability depends on what you've put into the system. So it's what's called the covered earnings. Generally, to put a number on it, it would end up being the majority of payments are between $300, which is clearly not enough to pay for anything, and $2,200. For April 2013, the average payment was $1,129. Not a lot, not enough to live a comfortable life on, but again, Social Security is a safety net. And the other thing is the maximum is $2,533 for 2013. So if you're making $113,000, you're going to be taking a cut from $113,000 to $30,000 a year, which probably going to take getting used to if you're used to making more money. Usually the payments aren't received until the 6th month. You have to be disabled for 5 months before receiving payments. That converts into a regular retirement benefit at full age. And this is one thing that's very important. If you end up having a disabled client or with a disabled spouse or disabled child, after 2 years of disability, you're automatically enrolled into Medicare. Which provides cheaper health insurance where you might not be able to get this health insurance. In addition to the retirement benefits and the family benefit and the disabled benefits, you also have family benefits and survivor benefits. So for the family benefits, you end up receiving it takes into account that you're not in a void. You're not just this person, but there's other people that are depending on you. So what provides is the spousal benefit the family benefit is about 50% of what you would normally receive on your own. If the spouse can receive it at 62 or above, but if at 62 it's reduced by a certain sum. One fact that a lot of people are usually shocked by is actually a former spouse can take under your amount. What that is if there's a former spouse that's you were married to for 10 years, she's under 62, or he's under 62, and is still unmarried, they can actually take a portion up to 50% of your payment. So a lot of people are surprised about that. I believe that doesn't count towards, there's a general limitation on what you and your family can receive of 150 to 180%. I believe that doesn't count towards that, but it's something that might make you uneasy, especially if you had a tough relationship with your spouse. So the other thing is your minor children and disabled children may receive up to 50%. So this ends up, again, using the 2,000 figure before, I may be able to receive, or my family may be able to receive an extra 50 to 80%. So that might go up to 2,500 or 3,000, or even possibly, what would that be? 3,600. So it, while not the best income for the family, it might provide extra benefits. The second thing is also you also have survivor benefits. These work similar. If the widow, this is one thing that's actually, widow can receive 100% of what you would have received after your death. And they can start receiving at 60, but this is reduced, and they can actually receive at 50 if the widow becomes disabled within either prior to your death or within 7 years of your death. But you do end up receiving a lower amount to count that you're receiving the payments early. It's to not give you more than your fair share. So this also covers for minor children and disabled children. You can get 75% for for dependent parents. They may be able to receive a percent. One parent can get 82.5%, and two surviving dependent parents can receive 75% each. Again, this is also subject to the 150% and the 180% total. So the last benefit I'm talking about with Social Security would be the Medicare benefits. With Medicare, first thing to be eligible, it's not the 67, it's 65. Or, as I said before, the 2-year rule, if you're disabled, on the disabled list for 2 years, you're automatically enrolled. One important factor on disability, or on Medicare, you're only eligible within the 7-month period of 3 months before your birth date, the month of your birth date, the month of your birth date, and 3 months after. So if you have a client that's rounding 65, it's good to tell them 3 months ahead of time, start applying. If you apply on your birth date, you might not be eligible until the next month. If you applied the last 3 months, it might take 2-3 months until you're eligible. So you want to apply on the prior 3 months. The general benefits of Medicare, there's two general schemes. There's the original scheme, and then there's the Medicare Advantage plan. The original scheme is there's what's called Part A insurance. This is in-house, the hospital insurance. This covers inpatient care and that sort of facility, that type of care. There's Medicare B, which covers medical insurance. This is more for outpatient, for medical equipment, preventative services. And then there's D, which is prescription programs. And a lot of these have co-pays and deductibles, so you can buy what's called a Medigap policy, which allows you to cover those gaps to get rid of some of the benefits. The other plan, the other method you can go is the Part C, which is Medicare Advantage plans. What these are privately ran or privately sold plans that are approved by Medicare. They're run like PPOs and HMOs. They usually provide both the A and the B insurance, and they usually provide some sort of D type, the prescription plan. And for this, you actually can't be sold a Medigap plan because these usually cover, they don't have the gaps that A and B may have. Just as a rough figure, for what you'd be expecting to pay for premiums for these, Part A, if you've had more than 40 work credits, as I said before, you're going to be paying Nothing. If you have 30 to 39, you're going to be paying $243 per month. If you have less than 30, you're going to end up paying about $440 per month. This is just for the inpatient care. For the outpatient care, which is Part B on the original, your payments are going to be between $105 a month and $335 a month. So this is going to be taking it out of that $30,000 that you've been making, or that you're earning, or your other assets. And the variability on that depends on what your income is. So obviously, I believe the higher level of the income is $214,000. So if you're earning $214,000 a year, this is not as big of a deal. But when you're earning the lower amounts, it could be more substantial. Part C, this completely depends on what the plan you have. If you have something that covers 100% everything, covers physical therapy, covers mental therapy, this, that, it's going to cover everything. Then it'll be more expensive. If it's something more basic, not going to cover that. Part D plans, the insurance, this is between $11 and $66, depending on your income. And Medigap can be, to cover those gaps, can be anything from $50 to a couple hundred. So it can be, your expenses can actually be anywhere from, let's say, $150, $160 if you're getting basic care, to maybe up in the $800s, $900s a month. While that sounds bad, the average care of someone that's elderly might be far out of that, or outside of that. So the fair market value premium might be somewhere in $1,500, $2,000, $3,000 a month, so the idea is you do get a benefit of that. The last question, kind of, I've been alluding it to the whole time on this, was what's necessary for retirement. And generally it's estimated about 70 to 80% of your pre-retirement income is important to keep the same lifestyle that you've had prior to retirement. Social Security on average provides only about 30 to 40% of what you need. So you're going to have to look to other assets such as pensions, savings. It's good to keep those, realize what Social Security is going to give you. There are Social Security calculators online. Try to figure out what Social Security would end up giving you if you continue at your current rate. And look at what do I need to make up investments. Another idea is you can buy real estate. You can buy something else, something that provides income by invest in dividends. So you're going to have to supplement that amount. Next, I'm going to talk about probably the more important, one of the bigger assets that we were talking about here, and it's one of the more important ones that you'd end up getting where a lot of your funds are going to be from, is retirement plans from your pension benefits. So the benefit of the pension benefits is, the benefit of the pension benefits, oh, I went out of place. Anyway, the benefit of the pension benefits is you end up receiving the funds. They're put aside tax-free. The investments end up growing tax-free, which provides a tremendous benefit, and they're not taxed until you actually receive distribution. So on plan benefits, just some terminology that you'd have to know is the difference between defined benefit plans and defined contribution plans. Defined benefit plan is something where the employer bears the investment risk. So what this means is, as it says, the benefit is defined. It's usually, you take the 3 highest average payments multiplied by, or your average highest years, multiply that by, let's say, 2% times the year of service. So what ends up happening is you're going to receive, so let's say you have 30 years of service and 2% is the rate that's used. You're going to end up receiving 2% times 30, 60% of your average income through the benefit plan. And this is what you're going to receive every year, regardless of what the investments are. A lot of companies have moved away from that because it's called bankruptcies with GM, with Delta and a couple other companies. The second one, which is what most companies have moved towards, is a defined contribution plan. This is, as I was talking about before, is an account program. The defined contribution plan is the company says, I'm going to take your income and give you 5% of your income every year. So what this is, your contribution is defined. After that, we have no idea what's going on. So if you have $5,000 every year thrown in over the 30-year period, that's going to be $150,000. That $150,000 could be $600,000. It could be $50,000. It completely depends on what it was invested in and what the market is. The three plans that, considering contribution plan, defined contribution plans are the most prominent ones. The three ones that people usually deal with the most are a 401k plan, which is an employer plan, an IRA, which is an individually set up plan, and a Roth IRA. The 401k plan is an employer plan where you can make pre-tax contributions of up to, in 2013, $17,500. If you're an older member, if you're over 50, you can get an extra $5,500 called a catch-up contribution. So if you're over 50, it's a good idea to make the full extent. You end up not paying taxes on this, or it's deferred. And a lot of times, the other benefit of this is a lot of times employers will actually match your benefits. So you get higher compensation, you get the tax benefit. The second is the IRA. This is individually established. You don't have as lenient contribution limitations. You end up having the contributions that can be made is you can only make up to, for 2013, is $5,500. Or if you're over 50, $6,500. There's no extra catch-up contribution. It's $6,500 period. The third one is the Roth IRA, which is has similar limitations. The only issue is this you're paying with post-tax dollars versus pre-tax dollars. Which one to pick depends on your particular situation, what your taxes are like now, what your taxes are like in the future. Depends on what you project the income to be. There's also the other thing is how old you are. If you're younger, it might be better to have a Roth IRA because you have more years. You end up paying taxes up front, but you don't pay taxes after that. You don't pay taxes on the investments. You don't pay taxes on distributions. So the next thing to consider is just after the DC plans is, when do I want to take my retirement? That's what most people, after you've put your contributions in, after you've received these, it's a good idea to take advantage of these. If the government's going to give you a tax break, tell clients to take advantage of these if they can. So the next step is, once I'm getting there, now do I take a normal retirement benefit? Do I take an early retirement benefit, or I take a late retirement benefit? Similar type of situation as you'd have for the Social Security. So the normal retirement benefit, this is usually the benefit that's offered. The plan offers just this amount. It's the plain vanilla, no adjustments. They say, so if you're getting 2% of your highest 3 average years of income times your years of service, so that'd be 60% income, it's plain vanilla, just that. This age is usually 65. Most plans can go as low as 62 if they want, but some of them, it depends on the industry you're in. It can be between 55 and 62 if the industry has a lower retirement age, or if someone is a policeman, a fireman, or an emergency worker, they might actually be able to receive normal retirement age as low as 50. The early retirement, without having any early retirement loss. If you receive early, two things might end up happening. One is what a lot of banks, what a lot of companies do, and a lot of employers have is there's a reduction. This is for two reasons. One, there's a reduction because you're receiving your payments early. By receiving more payments, you're going to have a reduced payment throughout the whole life of the payments. The other one is by receiving the payments early, they might have planned they're going to need these cash flows at this time, these cash flows at that time. So the sudden payment, the sudden need to pay early, might incur extra fees. They might have to sell securities, take losses, pay transaction costs. So usually there's a lower. You end up taking. It depends on the company. A hit on your average monthly payment. Sometimes companies will use a bonus for this, so as to reward you to leave early, and also to try to get rid of the older workforce. Usually doesn't happen, but sometimes it does. The second thing you can do is a late retirement. Late retirement, the benefits of this are one of two things. You can have either an actuarial increase, considering you're receiving it later, you're receiving less payments, they'll give you a higher payment each time. The other thing is plans are allowed to give you either the higher actual amount, or they have to give either or they can give both, or they can give you extra years of service. Where the years of service counts is, so let's say the number I used before, you have 2% times 30 years of service is 60% of my income. Let's say I only had 20 years of service. If I work an extra 5 years, I've just increased my income from 40% of my income to 50% of my income every year. That extra 10% might be worth those extra couple years, and working those extra couple years might have been a good idea because then I accumulate more assets. The other key consideration on taking early, unless the plan has a specific, because of the industry or because of police or whatever, you're generally, especially for defined contribution plans, you're not allowed to take prior to the age of 59 and a half, except in certain situations. You'll end up having a 10% excise tax on that. Certain situations would be death, disability, high medical costs, qualified education. If you owe the government money, they'll want their money. The other key information about this is on when you make your payments is you have to receive your payment on the later of the April 1st after you turn 70 and a half years old or your retirement. If you don't do this, you have what's called a minimum required distribution. So if that minimum required distribution was supposed to be $10,000 for that year, there's a 50% excise tax. So you want to make these minimum distributions. The other place this comes in hand is important is if you're a small business owner, you have a client that's a small business owner with a plan, if they're a 5% owner, even someone's a 5% owner, they have to take it the April 1st after they hit the age of 70.5. Or else you're going to be hit with this 50% excise tax. Now, after you decided when you're going to take it, so am I taking early, taking late, then you're stuck with the decision. Now, they give me all these options. They give me a single life, they give me joint and survivor annuity, they give me life term certain, they give me installment payments, lump sums. I don't know what any of these are. How am I supposed to know? So what a single life annuity is, usually if you're single and not married, they give you a single life annuity. This is, they take your lifetime expected, or your life expectancy, and give you an annuity that it would be the fair market value if you receive the same amount until your death, until your expected death. If you're married, you're required to have what's called a joint and 50% survivor annuity. Joint and 50% survivor annuity is, let's say I was supposed to receive $1,000 a year, and I have if I end up dying, then my spouse as a survivor will receive $500 a year, 50% of what I received. You also have 25%, 100%, and my amount gets adjusted on that. The joint and 50% is the required unless the spouse writes out of that. One key fact on this, and it's very important, is if the spouse writes out on it, courts will usually accept post-nup agreements, but a spouse cannot write out. Many courts will not respect the spouse writing out of the joint and survivor in a prenup agreement. So it's important to recognize that in the prenub, and then if it's in there, not rely on that prenub and make sure to get another affirmative after they've been married, after the spouse has been married. The third one is a life and term certain. This would be, I receive payment for life, and then I could designate another person to receive payments for, let's say, 5 years after my death or 10 years after my death. Another option is an installment, which would be a term payment. So I receive it for 20 years after my death. This is usually more common with defined contribution plans. And the last one is what most people are probably familiar with, are the lump sum payments. Lump sum payments, I receive everything up front. The one downside to the lump sum, there's usually heavily discounted. They are taking the fact that, as I said before, they might have to sell interest rate, or you might have to sell securities to make that payment. Another issue with this is if you have a defined benefit plan and it's unfunded, I forget the exact percent, I think it's 80%, then the plan might not be able to make lump sum payments. So you might have to take another type of distribution. Many of the defined contribution plans, on the other hand, you can take a lump sum payment, which actually gets me over to the next topic, which is called rollover. You may be able to take a lump sum distribution. However, it's important, unless you want all of it all at once, it's important to, especially if you move to another employer or you retire, it's important to move it into, to move the funds properly to not incur taxes. So for instance, if you have a new employer, if you want to move the funds to a new employer, you have $1 million worth of funds in your defined contribution plan. One thing you can get into trouble with is if you receive the check from your old employer and you hand it to your new employer, you've just received a distribution. This is all of a sudden taxable. All of a sudden, on the $1 million, you have $350,000 of tax, but the funds that you just ended up handing to your new employer, you don't have any access to that. So what ends up happening is you can incur a huge tax bill. You want to make sure that we just had an estate where they made payments to the estate. We ended up pushing it back and saying, no, void these. We want these to go directly to the trust, to the new IRAs, because we don't want to even mess around with being treated as if we received a distribution. All of a sudden, all the income is you have to pay all the income taxes on it. The other point also is for estate planning, retirement assets don't have this general step up in basis like other assets. So this is an asset, if it'll permits you to gift it, this is an asset that would be possible to gift, because as a gift you receive you receive the basis of the transfer. So you don't end up, if the transfer had a basis of 30, you end up receiving a basis of 30 if you receive it. So whereas if you waited till death, and in most situations, you end up having a step up in basis to the fair market value. Under this one, since you don't have that step up in basis, this would be an asset that you're not losing that step up in basis if you can gift it in some way, if it's permitted. The other thing is when beneficiaries receive funds, it's best push the payments out as long as possible to push those taxes, keep deferring them. You end up getting the time value of money on that, and it helps so you don't have a lump sum all of a sudden, and you can earn the income on the taxes that you would have been paying, and you'll pay the taxes on it. Don't worry about it until later. The last thing for the pension plans that a lot of people end up running into, you wouldn't think you would, but every once in a while it comes out. I had a friend last summer whose grandmother ran to this, where they actually gave the grandmother the wrong dispute, the wrong amount. You also run into situations where the plan administrator just happened to, he ran short on funds. He starts borrowing the funds and puts it in his own pocket. You don't know situations like that. So you end up running, you have to be prepared for what happens if there's impropriety. What happens if they say, I'm receiving a lower benefit. Let's say they only credited me with 25 years of service when I should have been credited with 30 years of service. So the general rule is first go see your attorney on it before filing everything. The first thing that's required is, or that make sure your clients know to see an attorney on it and not do it themselves and blow any of the statutes or blow any time that they can do. The first mechanism is you're generally required to follow the plan mechanisms that are meant to fix these, it's the plan mechanisms and appeal mechanisms to challenge any distributions or any statements. If this doesn't work, the next thing you can end up doing, you generally can go to the Department of Labor and make a formal complaint. A lot of times, the plan administrators, if they're improper, they will end up having taxes against the excise taxes against themselves and penalties that they will have to pay. And you can, through the Department of Labor and through the tax code, by disqualifying the plan or such other situations, you might be able to force them to make the proper distributions. The other avenue is you can also sue under, I forget the exact section, I think it's 506 or I forget the exact section. You can also sue in court to receive the payments or start receiving the payments. That's another avenue also on top of calling the Department of Labor. And then the last thing on the disputes would be with the pension benefit is if you end up having a situation where, let's say, like in the past with a WorldCom or a Delta, where it ends up going bankrupt, where they're so underfunded. Underfunded means they have more obligations to pay out and they don't have the assets to pay out these pension obligations. There's what's called the Pension Benefit Guarantee Corporation, PBGC. They will generally insure up to about 45% of the funds in the better situations, but that provides a safety net that allows you to, if you lost your net, if you were expecting to receive 60% of your income from that and 30% from Social Security, while a drop in 60% would be completely catastrophic, at least if you can receive 40%, you're still receiving roughly 50% to 55% of your amounts. It still helps provide that.
I appreciate everybody. We had a huge audience tonight, and if anyone, as Jeffrey said, wants to have a direct question, just email us at joe@pizzula.com. It's my last name. Or you can go on our website and just send a question in on the contact information. There's a course that we taught online on commercial lending or commercial borrowing a month ago that's also online. Thank you.